According to the Louisville Courier-Journal, Kentucky Governor Andy Beshear passed on President Trump's offer for federal help as protests continue in Louisville, saying, quote, "We had things under control, but appreciated the offer." The city braces for another night of protests as demonstrators are expected to keep calling for the arrests of the officers involved in Breonna Taylor's death. Some legal experts are poring through state laws to see if any additional charges could be proven in a Kentucky court. A new article from the Marshall Project examines the case's legal complexities for prosecutors. For more, I want to bring in Jamiles Lartey. He is a staff writer for the Marshall Project. Welcome, Jamiles. Great to have you with us. So, Jamiles, you write about a, quote, tangled legal doctrine that applies in Kentucky and 28 other states that has to do with self-defense, if I'm not mistaken. Can you untangle or explain that doctrine and how it appears to be at odds with the unique power police officers have?
Absolutely. So I think it's a good way to look at it is that police officers do have special laws that dictate their use of force when trying to arrest a suspect. There's also a ton of Supreme Court case law, most notably Tennessee v. Garner, which was where we get the fleeing felon rule. You can't shoot to kill someone who's running away and potentially about to, get away from police. That dictate when it's appropriate for officers to use force to do the job of being a police officer. But when it comes to the use of force in self-defense, police officers have the same rights and privileges as anyone else in Kentucky and in 29 other states. And now that may sound good. A lot of police reform discourse in recent years has essentially centered around protesters' demand that police be held accountable in the same way that anyone else would be. But the issue here is that police have rights and indeed responsibilities on the order of their superior officers to do things like burst into someone's home at 1 o'clock in the morning. Now, if you or I were to do that and someone were to assume that we were intruders and shoot us, we would be considered the aggressor under Kentucky state law, and we'd have no right to a self-defense claim. But police officers acting on a legally obtained warrant do have the right to do that. So you kind of create this legal stalemate where neither party can be determined to be the aggressor.
So it seems to me that the whole crux of this case, then, whether there was any wrongdoing on the part of police, seems to hinge on whether or not they announced themselves as police officers. Would you agree?
I think that's a really good point. And so what I would say is yes and no. I mean, something I noticed in Daniel Cameron's presentation yesterday is he did seem to go out of his way to point out that the officers knocked, which no one disputes. Kenneth Walker also says he heard knocking, and announced, which Kenneth Walker said he did not hear. And they were only able to corroborate that with one eyewitness. There were dozens of people in that apartment complex, and it's very tight-knit from what I understand, who told investigators that they did not hear the police announce themselves. So while it actually doesn't mean much in terms of whether the officers could be held criminally liable for shooting, because once they're fired at, they do have the right to return fire. But interestingly, right, what it may mean is that Kenneth Walker, now he was initially charged with a number of crimes related to firing at the officers, and those charges were dropped, but they were dropped without prejudice, which means that the prosecutors could bring them back. We are in a situation where if you could get a jury to believe the police officer's account and this one eyewitness versus Kenneth Walker's account and the other 11 plus people who said they didn't hear, you may be in a situation where Walker now could be convicted because your right to self-defense in your home does not apply if you know or reasonably should have known, is the literal language, that the people entering your home were peace officers.
But Jamiles, the fact remains that someone in the department or someone, maybe not one of these three police officers, but someone in the department made a mistake because they were acting on faulty information, and that resulted in the death of an innocent woman in her home. Are there no charges that can come as a result of that?
Well, I'd say this. I don't know that there's been a legal conclusion that they were acting on faulty information yet. That's been reported, and there is a parallel FBI investigation that may determine that. But whether or not, I mean, so the FBI, like the FBI investigation, could lead to additional charges, and I think a good example of that is the federal conviction secured in the 2015 shooting of Walter Scott. Officer Michael Slager was indicted by a state grand jury and went to trial, which ended in a mistrial due to a hung jury, and then subsequently pled guilty on federal charges. So yes, there are federal deprivation of civil rights under color of law charges that could be brought. There are obstruction of justice is absolutely within the realm of possibility if anything illegal or improper was done in acquiring that warrant. But the fact that they didn't turn up drugs or money doesn't necessarily mean that they were acting on false information. It just means that they're, the police can search something and find nothing and still have been legally allowed to search it.
Right. But her ex-boyfriend, who was the one that they thought would have the drugs or the money, had apparently not been in her apartment for several months.
Right. But what I'm saying is that as long as the information that led them to be granted that warrant was accurate, they cannot be held legally liable for acting on it. If it turns out that someone forged or otherwise doctored evidence,
right,
in order to get that search warrant, then absolutely there'd be federal charges in play. Now, I'll also say that, going back to that Walter Scott example, that happened under the Obama administration, and I think it is important to note that there is a different administration in control of the Department of Justice and the FBI now. And nothing that the Trump administration has done over the past 3.5 years suggests to me that this would be within their scope of concern or action.
Jamiles Lartey, thank you so much for joining us.
My pleasure.